The House will come to order. Chair recognizes Representative Hightower to present the bill.
Thank you, Mr. Speaker, members of the House. I first want to take a minute to thank a lot of...
Just a minute, Representative. The member is entitled to your respect and attention if you are in the chamber while he or she is in the well. If you need to have a conversation about other matters or any conversations, then please take them outside. Otherwise, this House will remain at order. Gentlemen may proceed.
Thank you, Mr. Speaker. I first want to take a minute to thank a number of my colleagues for taking the time to come and talk to me about this bill. If y'all notice on your desk, this is a bill that the Chamber and NFIB had scorecarded, and you'll find it on your desk. But instead of a lot of our members jumping, getting scared of that, they came to me and they asked me about this bill and got me to go into great detail why I brought this bill and what brought me to bring this bill. And so I thank each of you that gave me that opportunity to talk to you and let me show you my passion and understanding, get a little bit better understanding of why I was bringing this bill. This bill is aimed at protecting consumers that have been abused by their own insurance company. This is a very unique situation where an insurance company has been found by a judge or jury to have acted in bad faith, which means that they acted frivolously or unfounded in their actions in their refusal to pay a policy that their own client or their own customer had been paying on. And I want to stress that. This bill only addresses those policies where an insurance company by a judge or jury has been found to have acted in bad faith with their own customer. The person who's been paying them premiums for year after year and who has found themselves in need of the policy they've been paying for and then finds themselves stranded and abandoned. This is what I'm targeting. The way this works is that in order for this to be able to come to fruition, for you to have a bad faith claim in the uninsured or underinsured motorist area of our law, it's a two-lawsuit process. First, you have to file a lawsuit against the person who actually caused the accident that you were involved in, and you have to win that lawsuit. Oftentimes, that can take a year to 2 years, but you have to win that initial lawsuit for you to overcome the first hurdle, and that is the first hurdle you have to overcome, before you can proceed to filing an action against your own insurance company for not paying on your policy if they were found to have been underinsured or uninsured. The current law says that if an insurance company is found to have acted in bad faith, that insurance company is on the hook for 25% of the underlying policy, the underlying policy. So the way that will work, give you an example. Let's say that a person has an add-on uninsured or underinsured policy on their insurance, and that coverage is $25,000. The insurance company knows right then from that day that their only exposure as a penalty is $6,250. They know that's their only exposure on a penalty, as a penalty. Where you see some of this abuse, and this is from my practice, no one brought this bill to me and said, hey, will you bring this bill? I saw this abuse in my own practice. I saw that family that went to their insurance company that got denied that claim and lost their house and had to go without food for a couple of weeks and had to move in the trailer on their family's property and live there for 2 months without power. I saw that happen. That's where this bill is coming from. The same people that I turned away from my law office because I said, your case is so good, you don't need to pay me any portion of this. Your insurance is going to pay. And they didn't. That's what brought me here. But where you see this abuse a lot of times are on these low-end, small policy claims. These individuals, your blue-collar worker, like my parents, who are out there working 2, sometimes 3 jobs, which my dad still works 2 jobs to this day at 54 years old. Sometimes that's the only policy they can afford. But those are the ones that have the least to lose, so to speak, for the insurance company, because they're only on the hook for $6,250 if they act in bad faith against that person. So when I brought this bill, it was extreme because I was mad. I went after the insurance company, and I wanted to hit them hard, and it was extreme. One of the insurance guys even told me, "Mr. Hightower, this bill is nuclear." And I meant for it to be because I was hurt. But I went back to the drawing board with the help of a lot of people on the Judiciary Committee, and I commend them. They ran me through the ringer, 3 full subcommittee meetings, I think 2 of them for over 2 hours. But finally, I got it out of the full judiciary with a unanimous vote out of judiciary. And I'll tell you, I sit on judiciary non-civil, and I'd much rather be on the side analyzing bills than I am on the side getting my bill analyzed. But I was able to show my passion in those committee hearings, and they gave me time to hear the bill. And I've worked tirelessly over the past 2 weeks to try to be the #1 champion for my bill. Because as you may know, when you have the Georgia Chamber and NFIB working against you on something, it can be rather tough to get that out. But I knew that I was standing for something that I believed in. And when you stand for something you believe in, it's easy to come in this well and speak passionately about it because you believe in it. The current law says that if an insurance company is found to have acted in bad faith against their own client, their own customer in an uninsured motorist arena, their liability is only 25% of that underlying policy. What I'm doing is changing that to $25,000 or 25%, whichever is greater. Now, you got to look at the numbers here because I'm going to explain it. 25% is current law. I'm changing it to 25,000 or 25%, whichever is greater. And what that means is any policy that's $100,000 or greater will not be affected by my bill, because that would fall under the 25% is greater than 25,000. Everybody following? But the reason I did that is because the people that often get abused are your low-end policyholders. At $100,000, the current law was enough of a penalty to get the insurance companies to act right. But that $25,000 policy that was down at the low end, that oftentimes was not enough to get them to act right. It was $6,250, 25% of a $25,000 policy. It wasn't enough to sometimes hold their feet to the fire. So what my bill is aimed at doing is protecting that blue-collar worker that works day in and day out and has to pay that minimum policy because they don't have a choice. And when they do that and they go to their insurance company that they've been paying year after year on those premiums, I want the insurance company to think twice before they just write that off and say no, because we'll gain more money by keeping that $6,250 in our account and gain interest on it than we would paying that policy. I want them to think about that. And I want them to do the right thing. Now, they also said that this may affect premiums. I can tell you, I can't tell you this will affect premiums, and I don't believe they can either. But I'll tell you this, if they go out right now and if my bill passes and they change their premiums, it's because in my mind, that is telling me that they know they're going to act in bad faith. Because if they don't act in bad faith, this bill doesn't affect you. Act right, and this bill doesn't affect you. So I know some of us are scared of this bill because Georgia Chamber doesn't like it and NFIB doesn't like it. And I support a lot of their bills, but I'm not going to support big business at the expense of my blue-collar, hard-working constituents. I'm going to put them first. Now, I want you to also look at this. Their letter, if you look in the 3rd paragraph, 2nd line, it said it would require the insurer to pay all attorney's fees after the 60-day time period. If y'all would, if we can go to the bill right quick, if y'all would look at line 29. Now, their letter says it would require the insurer to pay all attorney's fees. So don't you think we should see a shall in here somewhere for those that read the code? We should see that it shall require that. But if you look at line 29, I believe it says, for reasonable attorney's fees, and if you go to line 28, it says the court in its discretion may hold the insurer liable to the insured for reasonable attorney's fees. There's no required there. And then if you read even further, it says, not just related to the uninsured motorist claim, but for the underlying action against the tortfeasor. That's just a straight out lie. If you look at the bill, it actually says you can only collect attorney fees that are related to the uninsured motorist bad faith action that you took out. So their own letter has two blatant lies, and if they're not lies, they're misleading. They're just misleading. So let me retract, because I don't want to call anyone a liar because I don't know where they started from, but let me just say it may be misleading, or maybe they should have came to me and let me explain my bill to them a little bit better. I think this bill will help those people that need help. I'm not out to get the insurance companies. And for anyone who knows, I'm an attorney, but I'm not out to line my pocket with this bill. If I was out to line my pocket with this bill, I'd have attacked the high-end policies, but I didn't. I'm only focusing on those small-end policies to protect those blue-collar workers and the people that can only afford those low-end policies. Mr. Speaker, I'll yield for questions.
You have some questions. Do you yield?
Yes, Mr. Speaker.
Chair recognizes Representative Mabra to your right for a question.
Thank you, Mr. Speaker. To my friend in the well, do you yield?
I do.
Isn't it true this is a good consumer protection bill that allows a policyholder to get fair and complete coverage under their uninsured and underinsured motorist coverage that they're not getting right now?
I believe that 100%.
Thank you, and I'll follow this bill all the way through. You did an outstanding job.
Thank you for your support. It's appreciated.
Do you further yield?
I will.
Chair recognizes Chairman Rogers to your right for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
I will.
Isn't it true when an insured turns over a claim to an insurance carrier, and in this case, it's probably could be a non-standard type carrier, is what you're referring to?
It could be.
That's not acting in bad faith. It's probably not a standard carrier.
That's probably correct.
Okay.
A lot of times I see this abuse not in the big name insurance companies.
Okay.
That's correct.
Further yield?
I do.
Once I have an accident and turn a claim in, it's really out of my hands, and it's up to the insurance company to represent me the way they want to represent me.
That is 100% correct.
Okay.
You're exactly right. Yes, sir.
Thank you.
Yes, sir. Mr. Speaker, with that, I'll yield the well.
Excuse me?
I'll yield the well, Mr. Speaker.
Gentleman has yielded the well. Okay, we have some members that want to be heard. Chair recognizes Representative Coomer to speak to the bill.
Thank you, Mr. Speaker. I rise in support of House Bill 303, and I will note that I'm rising as Representative Coomer, not as the governor's floor leader at this time. Something you may not know, I was not born with a lot of privilege. I was born into a poor family. My father was a 21-year-old Marine Corps veteran who was unemployed. My mother was an 18-year-old retail store clerk when I was born. I didn't come from privilege. But my family, my parents went on and helped themselves. My dad was the first one in his family to graduate from college and went on to seminary. My mother graduated from college, and they taught me a couple of things growing up. One is, we live in the greatest country in the world, and you can be anything you want to be if you work hard and you put yourself in determination and you make things happen. You can have anything you want in this country. It's a great place to be. The other thing they taught me was a principle that's in Proverbs 3:19 that says, open your mouth, judge righteously, and plead the cause of the poor and the needy. That is the mantra that led me to the path I took in a career. I like to speak up and judge fairly and plead the cause of the poor and the needy. And let me tell you what this bill does. This bill speaks up for the poor and the needy. This bill levels the playing field for people who are being taken advantage of, people who are the least in their community, people with the least opportunity, the least privilege, and it gives a little bit of leverage to the little man against the big giant corporation that is taking advantage of him and not giving him a fair shake. And that's what the bill does. And I just remind you before I sit down, one other proverb that says, if you don't listen to the poor when they cry, you'll cry and you won't be heard. If you vote against this bill, you're voting against not only the poor fellows and ladies in your neighborhood, you're voting against yourself, and you're voting against your own best interest. Thank you, Mr. Speaker.
Chair recognizes Chairman Earhart to speak to the bill.
Thank you, Mr. Speaker. This won't be an against the bill. I'm here to support this bill. Need some warm and fuzzy credentials after. That's not funny. Ladies and gentlemen, Representative Coomer did a very good job, as does Representative Hightower, explaining this. I just want to talk about the NFIB and the chamber, and I don't think you can get any more NFIB or chamber than Earl Earhart. I think I've won every award over the last 28 years that they each have, some of them 3 and 4 times. But every once in a while they get it wrong, just like sometimes blind hogs find acorns. They lost their acorn here, and they're just flat out wrong on this. I'm trying to get to be up to your standards, Representative Williams. Just get. I sat on the insurance committee for 16 years, and we heard about these bad faith cases, and they're just as much, and they're just as passionate, they're just as, well, not passionate, poignant as Representative Hightower laid out. These are folks that have been taken advantage of. This is bad faith. This is not just a mistake or a clerical error by these companies. This is when they've been, a finder of fact has said you operated in a bad way and you've harmed these individuals. That's when this kicks in, and this is not unreasonable. And I just wanted to say that if it's not going to raise rates, like Representative Hightower said, they got to go to the insurance commissioner. What are they going to do? Argue that we have bad faith cases and we want to raise rates? I don't think that's going to fly with the commissioner over there. Mr. Speaker, I just wanted to come up here and support this bill and ask you to support it as well. Thank you. I yield the well.
Chair recognizes Chairman Jacobs to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise in support of House Bill 303. I was the subcommittee chairman that wrestled with the bill and spent a lot of time working with Representative Hightower, and let me tell you, I have never seen, in the time I have had the pleasure of serving as a subcommittee chairman under Chairman Willard, I have never seen a member work harder to get a bill through subcommittee and to get a bill through a skeptical subcommittee than Representative Hightower worked on this bill, and I have the utmost respect for him and the process that he went through to get this bill to where it is today. I do want to take exception with the letter, and specifically the third paragraph that Representative Hightower mentioned. We spent an inordinate amount of time in subcommittee, literally hours, I would say at least 4, spread across more than one meeting, at least 2, maybe 3, where we tried to strike a balance with this bill. And it wasn't really until the bill emerged from full committee that we had hit the balance exactly right, in my opinion, with some final amendments that were made there in full committee. But we were always very upfront about what we were doing with the attorney's fee issue, and what the letter says about the attorney's fee issue in the third paragraph is completely incorrect. That is not what the bill does. And more to the point, it bothers me greatly that representatives of the organizations and their members who were present in the subcommittee meetings and who were present in the full committee meetings would characterize what the bill says in black and white in this way because it's not correct. With that, I hope the members of this body will view the letter with skepticism because it troubles me greatly. I spent a lot of time on this bill, and this is not what the bill does. It is not. As Representative Hightower pointed out, you can only get attorney's fees that were incurred after the demand was made, and 60 days after the demand was made. That's one point he brought up. Another point he brought up correctly, and this was an amendment that I worked on directly with Chairman Willard, the attorney's fees can only be awarded in the court's discretion, so the court gets discretion as to whether or not to award the attorney's fees. And finally, one point Representative Hightower did not bring up, the very last amendment that passed in the House Judiciary Committee made it so that there has to be a finding of bad faith in order to award attorney's fees in the first place. In other words, there's no automatic attorney's fees. There has to be a finding of bad faith. Then you're only possibly on the hook for attorney's fees that were incurred after the demand was made. So we're not talking about the original action involving the original tortfeasor. And even then, only in the court's discretion can they be awarded. That is not what this letter says. The letter is incorrect. The bill itself is a very finely worked out compromise that I think strikes the right balance. Because I think we struck the right balance in subcommittee and ultimately in the full Judiciary Committee, I support the bill. I didn't support it when it came into my subcommittee, but I support it today. And I am proud to support Representative Hightower in getting this bill through the House. He worked very hard on it, and it is a very, very good bill and a very good compromise. With that, Mr. Speaker, I yield the well.
Chair recognizes Representative Quick to speak to the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I rise this evening in support of House Bill 303. I'm not a co-sponsor on this bill. I do not practice this kind of law. I'm a family lawyer. I represent average Georgians with problems, and that is exactly who this bill helps. So when I heard late yesterday that the chamber was going to be opposing this bill, I could not understand that, and it bothered me all night. So I came to Representative Hightower this morning and asked him if he would mind if I spoke in support of his bill, because it reminded me of one of my favorite family stories. Keep in mind, this is one my mother likes to tell. When I was 5 years old and my father was trying to get me to do something, and I asked him why, and he said, because. And I said, why? And he said, because. And I said, because is a word and it is not a reason. And at that point, they knew they were in trouble, and it just sort of went downhill from there for them. But when you get these letters on your desk, I'm just reminded of that. And I'm not going to quote Proverbs, although I appreciate the fact that Representative Coomer did. I'm just going to say, in the immortal words of Shania Twain, this don't impress me much. And it especially doesn't impress me when it is aimed at a measure designed to help average Georgians. So I've been on a lot of lists in my time, and I am probably on a few in this chamber that I don't even know about right now. But I've also been on a few honor rolls in my time, and you do not want to be on the chamber honor roll if it means voting against this very good measure. And I don't appreciate a letter that's on our desk that contains false statements when it's targeted toward a bill like this. that somebody's worked on as hard as Dusty Hightower has worked on this bill for average Georgians. Ladies and gentlemen, I would appreciate your vote in favor of House Bill 303, and Mr. Speaker, I yield the well.
Lady has yielded the well. There are no more speakers. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Chairman Willard has the closing argument.
Thank you, Mr. Speaker. I don't usually do this, but I wanted to because of what we're getting as information. First of all, let me say I take great pride as chair of the Judicial Committee, as do the other serving on that committee, that we do not let things out that we feel are not good policy to the state and the people who reside here. That's first of all. And I think Mr. Hightower will tell you, when his bill first came out of subcommittee, he came into my office, and I said in my very amenable way, I said, your bill's not going anywhere. Because it was not a good bill. I said, we're going to send it back to subcommittee and let Mr. Jacobs' subcommittee continue working on it, because we had to get good clarity about what is this claim and this right an individual has when the company that insures that person has acted in bad faith. And that's what we're talking about here. It's not a matter of saying, well, the jury finds it one side or the other. It's a recognition that what they did was beyond what is recognized as the rights of a company to deny coverage that you have paid for over many years, many times, and you're injured as a result of another party, opposite party, and you have that coverage for that reason. This is like their liability becomes your coverage under your uninsured motorist. So I rise just to say, I'm sorry that the chamber and others are maybe taking this viewpoint about this bill. I have from time to time stood up to the chamber when they were wrong, and they, I think, recognized that I helped them on some things that were wrong. And I say their position in this situation is wrong. And I ask all of my colleagues to support the Hightower bill, House Bill 303. Thank you. Yield the well, Mr. Speaker.
Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 303 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? Have all members now voted? If so, the clerk will lock the machine on the passage of House Bill 303. The ayes are 153, the nays are 14. This bill, having received the requisite constitutional majority, is therefore passed.